Welcome, everyone, to our seminar, which is headed, I should say incorrectly headed, Committal Applications in the Civil, Fraud and Commercial Spheres. The reason it's incorrectly headed, although intentionally so, is because under the new dispensation of Part 81, which came into force in October of last year, the old language we're all so used to, the committal application, has been replaced by the contempt application. Now, Caley and I came up with the idea of this seminar because while we were updating over the last couple of months or so, a book we're involved in called Civil Fraud, and I very much hope that every single one of you has got a copy on your desk as we speak. We read all the new contempt cases that have been decided since the book came out in 2018. And we were surprised to find that no fewer than, well, considerably more than 100 decisions in the contempt sphere had been decided since November or October 2018. Now, it's right to say that not all of them are of world-shattering legal importance, but I think that number, decided in really 2.5 years, shows quite how significant contempt applications are in modern day civil litigation. And that significance is something I personally have had experience of. Last year, I think I spent about 3 months of my professional life devoted to one contempt application alone, which it ended up spending or involving 17 court, in fact, 18 court days devoted to it. And I was about to spend another 2 weeks on another contempt application before it was compromised. So from my own personal perspective and point of view, contempt applications are very much part of the meat and drink of modern commercial litigation. And the view we've taken, and I hope we can provide some inspirations on this, is that contempt should be part of, and no doubt is in the main, part of the armoury of the modern commercial litigator. And what we're trying to do in this seminar is attempt to discuss some of the key issues that are commonly in play and some of the recent decisions. We're going to speak to some slides which will be sent out after the seminar's over. And we've also done some longer notes, if you can bear to look at those, which accompany this talk. And Caley's going to kick off, and he's going to kick off from the kind of perspective of the claimant in contempt applications. And then I'm going to follow up with some thoughts broadly from the perspective of the defendant. I'm told there's a chat function which is readily available, and please feel free to pose any questions at any time you like. With that little introduction, I'm going to hand over to Caley. Thanks so much.
Thanks, Tom, for that introduction. I'm now going to try and share my screen so everyone can see the slides, which may well be the point where it all starts to go wrong. We'll see how we do. Hopefully, you can all now see the slides, and I'm told also you can adjust your screens to see how much of the screen you have us and how much the slides. So feel free to minimize me as much as possible, or as much as you would like, which may be the same thing. So here, just an overview of what we're going to be talking about. First, an overview of the jurisdiction, and then broadly the two types of contempt which are most relevant and will be the subject of this talk. Some tactical considerations, and in particular, striking out of committal applications, which has become an increasingly prevalent tactic we've seen in committal applications. The timing of the application, some issues on procedure and evidence, and then trial and penalties. So kicking off with the nature of the jurisdiction, this is obviously a quasi-criminal jurisdiction, and as such is distinct in a number of ways from any other civil proceedings. The most immediate and perhaps most significant difference is in terms of penalty. It's of course extremely rare to see the civil court imposing penalties which are most naturally associated with the criminal court, including fines and, in serious cases, substantial terms of imprisonment. But the quasi-criminal jurisdiction has impact in other ways, some of which may seem superficial or even trivial, but reinforce the extraordinary nature of this jurisdiction. For example, in the new Part 81, Rule 81.8 provides specifically that trials of contempt applications should be rogued. Now, that in itself is a relatively rare sight for a commercial practitioner these days, even before remote hearings. But I believe this is the only place in the CPR that the rules themselves actually dictate that hearings should be roved. Similarly, the requirements for transparency and open justice are even higher than in other civil proceedings. It's actually comparatively rare for contempt hearings or any part of them to be in private, and there are strict procedural safeguards in place to be adhered to in such cases. A particular and perhaps more far-reaching consequence for claimants of the quasi-criminal jurisdiction is that the claimant is cast, at least to an extent, in a quasi-prosecutorial role rather than merely an adversarial one. They are expected, at least to an extent, to uphold standards of neutrality in terms of the presentation of their case, which again may well not come naturally to the commercial practitioner. The other significant difference is, of course, that the standard of proof is higher. This is not a groundbreaking revelation to anyone on this seminar, that it is higher to prove something beyond reasonable doubt than on the balance of probabilities, but it does create challenges in a number of ways. It's, of course, literally a higher threshold, and so the evidence to prove it must be that much more cogent. But the lack of familiarity for the civil practitioner with the criminal standard is an issue in itself. Experienced practitioners, of course, have a feel for a case when it's at the civil standard, or indeed the various other standards that appear in civil proceedings, such as summary judgment or for injunctive relief. Practitioners in the civil field may not have the same instinct or the same immediate familiarity with what's required to show a judge that the elements of the contempt are made out such that the judge can be sure beyond reasonable doubt. The two types of contempt we'll be considering mainly in this talk are, first, that comprising a breach of trust, breach of court order or breach of undertaking, which is perhaps the ones with which most practitioners are familiar. And a second, perhaps less important to the civil practitioner, but it's nonetheless of some importance, the contempt that arises out of the giving of a false statement of truth. The first of these is a civil contempt. The civil contempt jurisdiction plays two roles. The first relates to the court's interest in ensuring that its orders are upheld, and as a corollary, breaches of its orders are punished. But there is a second jurisdiction here at play, which is the interest of the private litigant claimant in procuring compliance with an order made by the court. That order was presumably made to protect the interests of the claimant and so for its benefit. And so in exercising the civil contempt jurisdiction, the court is furthering the ends of the private litigant, which in one sense makes the imposition of criminal sanctions all the more extraordinary. The second type of contempt, the false statement in a document supported by a statement of truth, is a criminal contempt. There is no coercive element to it, but rather its purpose is to preserve the authority of the court and to discourage, by punishment where necessary, acts which interfere with that authority. There are substantial procedural distinctions between the two types of contempt, the most significant being that the latter kind, the criminal kind, requires permission. We'll cover this in more detail later, but there are also significant differences in terms of timing. Because of the coercive element of the civil contempt, it is much more usual, and there's a much stronger case for an early trial of the contempt allegation, quite possibly before the substantive trial in the action. The latter type, the criminal contempt, there is no such justification, and it's much more unusual to have the trial of the committal before the substantive trial of the action. And we explore the tactical impacts of that distinction later in this talk. The classic statement of the elements of civil contempt remains that of Mr. Justice Christopher Clark, as he then was, in Masry and ICIC. And they are, first, the defendant must know the terms of the order. Secondly, it must be shown that the defendant acted or failed to act in a manner which involved a breach of the order. And thirdly, they knew of the facts which constituted the breach. It is perhaps the last of these that's most apt to cause confusion, and that's where I'll start. Motive is not a necessary element of civil contempt, though it may be an aggravating factor when it comes to sentence. Rather, what must be shown is that the defendant intended the act or omission, but not that he intended to breach the order by it, or even that the defendant knew the act or omission would amount to a breach. The position had, to an extent, been clouded by a 1993 decision out of Caley and Squatriti, which led to suggestions that in order to amount to a civil contempt, the breach must be contumacious, a word which invariably appears in contempt proceedings and never outside contempt proceedings. That position, however, has now been comprehensively overruled, and the very recent decision of the Court of Appeal this year in Varma and Atkinson confirmed the position that O'Talley has been overruled, and the law is now settled that the breach need not be contumacious. What must be shown is that the defendant knew of the facts which constituted the breach, not that it was a breach. Nonetheless, while motive is not a requirement, it's important to note that acts which are casual or accidental will not amount to a contempt. This principle is well established going all the way back to a case called Stankham and Trowbridge in 1910, which has been upheld on numerous occasions since then. A good example is a respondent to a freezing injunction who may, for example, provide asset disclosure in the honest belief that the value of a particular asset is below the threshold for disclosure. The defendant will not be taken thereby to have known of the facts which constituted the breach. In particular, the defendant does not know the true value of the asset, which puts it above the threshold if he honestly believes it to be below it. Similarly, an inaccurate valuation of an asset given as part of asset disclosure in response to a freezing injunction will not amount to a breach if it's a genuinely held belief. Once again, the defendant will not know of the facts which amount to a breach. We now consider some of the potential pitfalls in showing a civil contempt has occurred. This slide could go on for quite some time. The number of pitfalls is large, but we'll just consider a few of the most important ones. The most important point to note at the outset is that each element of the contempt and any fact essential for the finding of contempt must be proved to the criminal standard. So the burden on the claimant is, as you will be able to judge, a very high one. A few points of general application. As with any civil fraud claim, many allegations of contempt will rely on inference because of the difficulties of obtaining direct evidence. Because of the higher standard of proof in contempt of applications, the task of proving facts in that way is made all the more difficult. The claimant must go much further than merely showing the facts support the inference, which the court is invited to draw, or that it's the most likely inference. The claimant must show that the inference of guilt is the only inference which can be drawn from the relevant primary facts. If the court concludes that there is more than one inference that can reasonably be drawn from those facts, and one of those inferences is inconsistent with the contempt having occurred, the application will fail. So you'll see from that that it's a very, very high burden indeed on a claimant trying to prove contempt by inference. Otherwise, the rules of evidence provide that the claimant can rely on any evidence that would be admissible in ordinary civil proceedings. Evidence provided on disclosure in the course of previous proceedings, and even primary facts recorded in earlier judgments are all, in principle, admissible in contempt applications, subject considerations as to the weight to be given to such evidence. For example, in a 2018 decision, Supermax Offshore Holdings and Malhotra, Mrs. Justice Cockrell refused to exclude evidence and disclosure given in earlier proceedings on a contempt application on the basis that that would be an unnecessary limit to the evidence before the court. As to proving the specific elements of a civil contempt at trial, the first, that the defendant knew of the terms of the order, will often be the most straightforward to prove. Typically, the order will have been personally served, although in the new part 81, as I think Tom will come on to, it's not entirely straightforward whether the court can still dispense with personal service. Or an order will have been made which can satisfy the court that the method of service was sufficient to draw the attention of the defendant to the terms of the order. So proving knowledge of the terms is perhaps the least of the worries of a claimant in a committal application. The requirement for a penal notice, the old rules were very clear that this requirement could be dispensed with. The position is slightly less clear under the new rules. Again, I think Tom will come on to this in a bit more detail, but our assumption and the case law so far suggests that the law is largely unchanged in this respect. Proving that an act or omission which amounted to a breach actually occurred will often be the most difficult aspect of the contempt application. Freezing injunctions provide a good example of this. They do not normally act as an absolute bar to all transactions, for example, under the ordinary course of business exception. In many cases, assessing whether a particular transaction actually amounts to a dissipation will be far from straightforward. The process will require intense scrutiny on both the terms of the order itself and the acts complained of by the claimant. As to the terms of the order, it's important to note the order will be construed strictly. Any ambiguity as to the scope of the order or the requirements on the defendant under it will likely be resolved in the defendant's favour and preclude a finding of contempt. The order is construed on its face, albeit orders can include and incorporate references to other documents, as was determined in Keir and Watson, the case Tom mentioned earlier that took up so much of his year last year. However, the role of background or surrounding circumstances is not the same as in contractual interpretation. The surrounding circumstances in particular cannot give an order meaning which the words themselves do not bear. The justification for that approach is very clear. Respondents to such orders and third parties need to understand exactly what they are required to do or required not to do, precisely because of the serious consequences in terms of contempt. Mr. Justice Hilliard, with particular regard to the effect of such orders on third parties, said in the Group 7 case, although an unswervingly literal approach is not appropriate, and the context in which the words appear may well affect their construction, it seems to me that the court must adopt the meaning which, in the context, the words naturally bear, rather than any special but unexplained meaning. The meaning of the order, therefore, cannot change according to the general circumstances of the case or the identity of the individual who is said to have acted in contempt. The meaning must be constant and objectively verifiable. As to the act in question, which is said to amount to a contempt, particular attention must be paid to ensure that it does actually breach the order. That sounds very obvious, but it can raise issues in terms of, for example, timing. A good example comes in the form of the rule, what's known as the rule in Reed Jones, decision of Mr. Justice Mumby, as he then was, and again considered at length in Keir and Watson. The point is that when, for example, a mandatory order requires someone to do something by a particular time, action taken after that time, by definition, cannot amount to a breach of the terms of the order. And in Keir and Watson, that had the effect, in particular, of whistling down the number of counts of contempt very substantially indeed at trial. A final potential pitfall is the defense of impossibility. A defendant may say, well, I didn't comply with the terms of the order because I wasn't able to. A particular example might be a mandatory order requiring delivery up of some goods or of information which the defendant simply doesn't possess and so cannot deliver up. The evidential burden initially falls on the defendant to produce some evidence that compliance was impossible. It's to be noted that compliance must be impossible and not simply difficult or inconvenient, and that arises from a decision known as Perkia Foods Limited and Halo Foods Limited from the Queen's Bench Division in 2019. Once the defendant has satisfied that burden, however, the burden shifts once again to the claimant to show, as always to the criminal standard, that compliance with the order was possible. The position is somewhat different in the cases of voluntarily given undertakings. A defendant who wishes to raise a defense of impossibility when he has himself undertaken to do something has a more difficult time of it. In Discovery Land and Jaya House, it was held that a defendant who knowingly gives an undertaking that cannot be fulfilled cannot escape the consequences of non-compliance as a result of that impossibility, unless it can be shown that it wasn't clear at the time the undertaking was given that compliance wouldn't be possible. As to the second species of contempt, the criminal contempt, this relates to giving a statement which is false and supported by a statement of truth. And CPR 3214 provides proceedings for contempt of court may be brought against a person if he makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. The jurisdiction is therefore very wide in scope. The false statement in question can be founded on a statement of case, an affidavit, a witness statement, or even, though such cases might be expected to be rather rarer, expert reports. It will not, as we're sure have escaped your attention, that in a large number of commercial cases, perhaps even a majority, at least one side, if not both, alleges that the other has put forward a case in a statement of case or given evidence knowing it to be false. The procedure for contempt applications of this kind is again to be found in the new Part 81, and perhaps the biggest distinguishing feature is the requirement to obtain permission under Rule 81.35b. The requirements for permission, however, remain unchanged, and as is stated in the leading case of KJM Superbikes Limited in Hinton, a 2008 Court of Appeal decision. The claimant must show a strong prima facie case that the elements of contempt are made out, namely that the defendant knew the statement supported by a statement of truth was false, and he knew that the statement was likely to interfere with the administration of justice. The requirement mentioned earlier that the claimant act in a quasi-prosecutorial capacity is equally applicable in a permission application, and the claimant in the case of TBD Owen Holland Limited and Simons was criticised for falling short of that standard in a 2020 decision of the Court of Appeal. As to the first element of the test, which is likely to be the most problematic, the defendant may actually know that the statement is false or be reckless as to its truth. Either of those, however, requires a level of engagement by the defendant with the subject matter of the statement. A good example is the case of Newson Smith and Al Zawai, where no less a counsel than Thomas Grant QC persuaded the court to dismiss an application for committal at the permission stage on the basis that while the defendant had not taken sufficient steps to check whether a statement was true, this was no more than carelessness. Mrs. Justice Whipple said, "There must be a subjective element, that is, a conscious engagement with the issue which is the subject of the statement, before it can be said the statement, if it turns out to be untrue, was made recklessly and thus without an honest belief in its truth. Anything less than conscious engagement is likely amount to mere carelessness." I agree with the respondent and reject the applicant's looser approach to recklessness. So that was a substantial victory for Mr. Grant QC in that case. Because of the nature of the criminal contempt and its role in upholding the authority of the court, public policy plays an even greater role than it does in the civil contempt jurisdiction. And the case I just mentioned of TBD, Owen Holland and Simons in the Court of Appeal sets out in some detail the questions to be determined on the question of whether public policy interests are engaged such that the committal application should be allowed to proceed. The first of those is a straightforward one, is the case one in which the public interest requires contempt proceedings should be brought. So a very broad question to be answered by the court then. The second is whether the claimant is a proper person to bring the proceedings. So that goes back to the quasi-prosecutorial nature of the claimant's role in such applications. Similarly, the court must guard against the risk of allowing vindictive litigants to use contempt proceedings to harass persons against whom they have a grievance. So the state of mind of the claimant does play a role in the criminal contempt procedure. And this is another instance of the court enforcing the quasi-prosecutorial role. Essentially, the question is whether the claimant can be trusted to uphold the standards of fairness and neutrality expected by the court on such applications. The final question is perhaps the most significant in this jurisdiction. Is it proportionate to allow the application to be brought? That involves consideration of a range of factors, including an assessment of the strength of the case against the defendants, the amounts in terms of money which were involved in the proceedings in which the allegedly false statements were made, and how those proceedings were affected by those statements, the likely costs on both sides, and the amount of court time likely to be involved in managing and hearing the matter. It's worth bearing in mind on this issue, as I mentioned earlier, in a great many cases, one side will allege the statement of case or witness statement contained deliberately untrue statements. The time for determination of the truth or falsity of those statements is at trial as part of the factual determination of all factual issues in the case, and not in satellite litigation and thereafter. Ultimately, the question of whether the public interest is served is a question of judgment, not one of fact, as was confirmed in the case of Cavendish Square Holdings and MacDessie. Christopher Clark, LJ, giving the leading judgment, said, "The critical question in this and every case is whether or not it is in the public interest that an application to commit should be made. That's not an issue of fact, but a question of judgment. The discretion to permit an application to commit should be approached with considerable caution. It is not in the public interest that applications to commit should become a regular feature in cases where at or shortly before trial, it appears that statements of fact in pleadings supported by statements of truth may have been untrue. Whether an application for committal is in the public interest will depend on a number of considerations, many of which have been considered in the authorities, including the significance of the statement, the clarity of its meaning, the strength of the contention that the maker of it knew it to be untrue, the status of the maker, the seriousness of the consequences of it having been made, the length of time over which and circumstances in which it was maintained, and any explanation as to why it was made." So in addition to the breadth of the jurisdiction, it's important to note the court is not going to welcome applications after the end of trial by aggrieved litigants seeking to commit the other side. And finally, from me, before I pass over to Tom, some tactical considerations which are perhaps particular to claimants. The benefits of securing a successful contempt order, particularly civil contempt, are very clear. They can, of course, be effective in securing compliance with the order. Ultimately, that should be the claimant's primary purpose in pursuing a contempt application in the first place. But there are other wider tactical benefits. Any case which turns on credibility will be severely affected by a contempt finding against the defendant. A defendant who has been found to be in contempt and may even be, for example, giving evidence from one of Her Majesty's prisons would be at a considerable disadvantage in the proceedings. In some cases, finding in the contempt trial may actually determine issues in the case. In the Ablyazov litigation, for example, Mr. Ablyazov had denied owning or having any interest in numerous entities which were said to be involved in fraudulent depredations from the bank. In the course of his committal trial, it was found to the criminal standard that he did in fact own and had controlled several such entities. And so it was not open to him, it would not have been open to him anyway at trial to take those defenses any further. While it's not the aim of this talk to dissuade practitioners from pursuing contempt applications, there are, of course, alternatives open to claimants, which will be, in most cases, cheaper, in many cases, less risky, and in some cases, just as effective as a contempt application. And the three which occur most often and are perhaps most relevant are unless orders. Of course, whenever there's been a breach of an order, it would be open to a party to apply for an unless order, giving the defendant effectively one final opportunity to comply before some sanction is imposed. Striking out a defendant's defense or debarring him from defending the proceedings would be a standard such remedy, and again was used extensively in the Ablyazov litigation, where Mr. Ablyazov himself and a number of other defendants had defenses struck out and were debarred from continuing to defend the proceedings, largely on the basis of failures of asset disclosure in response to freezing injunctions. A second option, again, particularly relevant in the freezing injunction context, is receivership. In cases relating to asset preservation, where a defendant is either taking steps to dissipate assets or is suspected of doing so, the appointment of a receiver or a receiver and manager in more extreme cases may be appropriate and may give a greater degree of security and be a more effective remedy even than committal. And that's particularly so against, for example, defendants based overseas, where the threat of imprisonment is not, in practical terms, such a strong motivating factor. A final alternative relates to cases where disclosure has not been given or is inadequate. In a large number of cases, of course, freezing injunction disclosure requirements are not met or not met as fully as the claimant would like. In such cases, the court may make an order for cross-examination on assets if it is proportionate to do so. In a decision earlier this year in Privet Bank and Kolomoisky, the court determined that if the claimant already had sufficient information to protect its position, even if it perhaps was not as much information as the claimant would like, such an application is likely to be dismissed. In more extreme cases, the court may take control of the disclosure process altogether, including granting orders for example, inspection or imaging of electronic media, and such orders are becoming increasingly common in commercial litigation. And with that, the end of the undercard, I will pass over to Tom.
Thanks very much, Caley. Thanks for those kind words. I think have I managed to I think I've managed to shift over to my own slides. So, as I mentioned at the beginning, Caley was dealing with substantive questions which a claimant has to confront when deciding whether or not to launch a committal application, and a number of the issues that he raised related to whether or not perhaps one can, as a claimant, utilize other tools in the armoury of the commercial litigator to achieve the same end. And he ended his talk with references to possibly going for unless orders or receivership applications, and indeed in Ablyazov, as he and I know, because we were on different sides, before the bank eventually applied to commit Mr. Ablyazov, they obtained a receivership order of gargantuan proportions relating to hundreds of companies allegedly in Mr. Ablyazov's control. In the end, I think the bank took the view that the receivership order was not sufficient, and then moved eventually to a committal application, which I think it's fair to say took up perhaps 16 days of Caley's time rather than the 18 days taken up by me, but a significant amount of his own professional time committing Mr. Ablyazov. I now turn to questions for the defendant to ask when they are hit with or served with a committal application. And it's fair to say that one of the real growth areas in contempt litigation now is applications to strike them out. Now, under the old rules, there was when I mean the old rules, the rules that pertained until the 1st of October of last year, there was a clear and unequivocal statement in the rules that a defendant who had been served with an application to commit could strike out or apply to strike out that application under a variety of grounds. Now, for reasons which escape me, that rule has been effectively abrogated and not replaced under the new Part 81. Nonetheless, undoubtedly, and judges have said so since the 1st of October, nonetheless, the court has a continuing and undoubted inherent power to strike out a committal application. And there are a large body of dicta in the decisions over the last 10 years or so, which shows that judges are really wise to the fact that committal applications can be used for oppressive and vexatious purposes. And undoubtedly, grievances develop in litigation, and people sue other people not simply for monetary remedies, and people issue committal applications not simply to ensure that defendants comply with their obligations. And judges live in the real world, and judges understand that committal applications are capable of being abused. And given the penalties that can be imposed upon defendants, which Caley mentioned, and I'll mention a little later in my presentation, there's a real risk of defendants being under some severe penalties imposed by judges who have been potentially bamboozled by litigants who are motivated by revenge or what have you. And there's a very good statement, I think, and one which has been quoted a number of times subsequently by Mr. Justice Hamblin in the case of Maximov, which you have on your screen now, which shows that the courts will be willing to intervene early if they take the view that a committal application has been issued and is being pursued vexatiously. And indeed, that costs orders can be awarded in order to punish claimants who have abused the jurisdiction. I think in Maximov, the costs on both sides were, in the hundreds of thousands. And Mr. Maximov, it was held that the application had been made against him in a vexatious and oppressive way. And Mr. Maximov obtained a costs order, I think, to the tune of £500,000 against the applicant bank who had, so it was held, abused the jurisdiction. Now, bullet point 2 of this particular slide, I set out the kind of grounds, the typical grounds a defendant might wish to rely upon when applying, if they seek to apply to strike out a contempt application. Let me just very briefly go through, then I'll develop the points a little further later on. Question 1, is the application being brought vexatiously or oppressively? Is it being brought for the purpose of actually upholding the court's authority or to ensure compliance with an order? Or in fact, is it being brought with a view to do down a defendant the claimant has an animosity or an animosity towards? Very large number of examples of that in the authorities. 2, Henderson and Henderson abuse. Again, I'll come back to that, but you'll remember that Henderson and Henderson is the principle which has had the longest life of any principle developed in the early 19th century, still being used and applied in all sorts of areas, but it's been held recently that Henderson and Henderson abuse applies and has a real meaning and purpose in committal applications. 3, prematurity. I'll come back to that. That has a much greater application. Indeed, its sole application is in the criminal contempt arena. 4, is the breach only a technical one? Or 5, and this is simply bringing into line the jurisdiction to strike out a committal application with part 3.4, which is, of course, the jurisdiction to strike out a statement of case in normal civil proceedings. Has there been a breach of a rule or practice direction? I'm going to develop some of those points in a little while. The final question, if you as a defendant do issue an application to strike out, when should it be heard? Now you may say, well, isn't there an obvious answer to that question? A defendant wants to have the application made against them dismissed as soon as possible, and will want to move the application and bring it on well before any steps have been taken in the substantive committal proceedings, and certainly well before the trial of the committal proceedings. Now, in the main, that's no doubt correct as an analysis. But if you are saying as a defendant, this applicant, this claimant has brought this application maliciously against me because they have an animosity or an animus against me, that may be quite difficult to establish on an application heard without oral evidence. And so in that kind of scenario, it may be required, or maybe the better procedural step from the defendant's point of view, to have the application heard at the same time as the full-blown trial of the committal application. Of course, that means that money has to be expended in getting yourself to a full-blown trial, and the defendant has to suffer the potential risk of the trial going ahead. But I'll give an example in a couple of minutes of precisely such a step being taken, and the strikeout application brought by the defendant coming on at the same time as the underlying committal application brought by the claimant. So just to develop a few of those points a little more. Here, the slides, as you'll see, says strike out for oppression or illegitimate purpose. Self-regard requires me to quote the leading case of Sectorguard and DN, a case I argued 11 years ago, but which I'm delighted to see, having done a little Bailey search this morning, was cited by judges no fewer than 12 times in the last 12 months. A decision of Mr. Justice Briggs, as he then was, and really the key modern decision on oppression and illegitimacy, and endlessly quoted by the judges ever since. And I would commend it as a very good statement in short terms of the jurisdiction. And I won't read out the quotation, but you can see it on the screen. And very much in the same line, in the same vein as what Mr. Justice Hamblin said a few years later in the Maximoff decision I just quoted. Let's go. Sectorguard was decided in 2009. Let's go straight to 2020, and a case which really an extraordinary case called Navigator and Deripaska. Now that was the latest, possibly the last, but certainly the latest step in ongoing litigation between Mr. Chinookin and Mr. Deripaska, which had been fought across various jurisdictions and was undoubtedly, on any view, a grudge match. The immediate background to it was that Mr. Deripaska had issued a private prosecution against Mr. Chinookin. And in response to that, Mr. Chinookin, via his company Navigator Equities, issued a committal application against Mr. Deripaska, as the judge described it, a matter of tit for tat, issued in revenge. And the way that the applications were case managed was that the underlying committal application came on before Mr. Justice Andrew Baker. Mr. Deripaska had issued his own application to strike out the committal application as being abusive. And instead of it coming on in advance of the trial, it came on at the same time as the trial. And the way it was managed, which was quite imaginative from the defendant's point of view, was that the claimant's evidence was heard. In fact, Mr. Chinookin decided not to give evidence himself, which was possibly a bad move. And the only evidence served on behalf of the claimant was from the partner in the solicitor's firm acting for Navigator. And that partner was cross-examined by Mr. Deripaska's counsel. And he managed to achieve some significant admissions during that cross-examination. And then, before Deripaska's own evidence was called, Mr. Deripaska's counsel then made his oral application to strike out the claim. And the judge gave an extempore judgment saying, well, I'm going to accede to that application. And then a couple of months later issued an immensely long judgment explaining why he had come to the conclusion that the application was indeed abusive and should be struck out. And in the context of his judgment, he said a number of things which Caley has already alluded to in his talk. Let's just very briefly go through them. A committal application is a form of quasi-criminal process. It's not absolutely criminal because the civil rules of evidence apply, for instance, and it's heard in a civil court, and of course there's no jury, it's decided by a judge alone. But it has quasi-criminal aspects to it because, of course, at the end of the day, it is punitive, and the court has the power to sentence the defendant, contempt law, if they're found guilty, to a term of imprisonment. Hence, the claimant assumes the role of a quasi-prosecutor. Again, Caley's mentioned that. Claimant must not be brought with a view to vexing or harassing a defendant. Well, that's nothing more than we've already said. But then some very important paragraphs in the judgment of Mr. Justice Andrew Baker about the way a claimant should approach the prosecution of the committal application. Should act dispassionately and objectively, must present the facts fairly and with proper balance. Evidence should avoid tendentiousness or argumentativeness. Now, in the Navigator case, the affidavit served by the claimant in support of its committal application was filled with statements about how Mr. Deripaska must have been lying in that regard, or it was preposterous that he said this or that. It was a real exercise in affidavit advocacy, and the judge really did not like it. And indeed, the tendentiousness spilled over into the skeleton arguments. And again, the judge made some very scathing comments about the fact that the skeletons that were served on behalf of the claimants were not presented in a neutral, fair way, but were full of Deripaska's obviously lying in this regard or that regard, etc., etc. And that really did not commend itself to the judge. And from a practical point of view, it seems to me that if you are about to advise your client or about to embark upon a committal application, just spend 10 minutes reading the relevant paragraphs of Navigator and Deripaska and make sure that your correspondence leading up to the application being issued and thereafter is written in the most vanilla format. Do not default to possibly the type of tone that we all possibly default to in commercial fraud litigation. Stop, don't. If you have a natural desire to do so, which we all have, just don't do it, because it can come back to haunt you at any hearing of a strikeout application or the trial. just cut down on the aggression. And in fact, there's a particular sentence or particular paragraph in Navigator where Andrew Baker J said that having been involved in commercial litigation for 30 years, he'd noted a real shift in tone and correspondence, and he deprecated it. And that paragraph's actually been quoted with approval by the Court of Appeal since. Now, look, it's fair to say that that was a case involving a historic contempt. Well, by historic contempt, I mean a case where it was alleged that Mr. Deripaska had breached an order, but had then complied with it subsequently. And therefore, there was no question of an ongoing contempt. There was no question of any order having a coercive effect on Mr. Deripaska. It was all very much in the past. And that was one of the reasons the judge didn't understand the level of aggression that was being leveled against Mr. Deripaska. I think it's right to say that in the kind of situation, possibly the more general and usual situation which we'll all be in, which is of seeking to commit a defendant who is in ongoing breach of an order or undertaking, then the courts are going to be less likely to insist on this sort of holier than thou quasi-prosecutor standing above the fray. Because in that situation, your client, if you're acting for a claimant, has a real and immediate interest in securing compliance with an order which a defendant, so you will say, has refused to comply with. Now, in that situation, a little bit of aggression is not unlikely or not unrealistic. So Navigator is a case worth looking at, but it has its limits, and it is probably more pertinent, or definitively more pertinent, to the historic contempt as opposed to the ongoing contempt case. Other grounds for striking out. I've already touched on this briefly. Let me just go through three potential grounds that you might be able to rely upon if you're acting on behalf of a defendant. The committal jurisdiction has no limitation period. There's no rule or law that says you can only apply to commit for breach of an order or undertaking after 2 years or 3 years or 6 years. The general rule stated by the judges is that where there has been a breach of an order or breach of an undertaking, and you wish to enforce that by committal proceedings, then the claimant is expected to act quickly and not to let the contempt or the breach sort of lie on the file until they wish to sort of take it off the shelf, dust it down and launch an application. Now, what that means in practice is that if a claimant knows of a breach or knows of an alleged breach and then carries on with the litigation and then a few months or a few years later decides to resurrect that breach and found a committal application upon it, then the defendant will have a powerful argument to say that the claimant has lost its opportunity to enforce that breach via a committal application. An example is the case of Kieran Watson, which I was in last year, where the application was issued in 2019, came on in 2020. But one of the orders that was sought to be relied on as allegedly having been breached by Mr. Watson dated back to 2016. And one of the arguments we deployed was that, look, what the claimant had done, it knew that it had a case for saying that Mr. Watson had breached an order in 2016. It didn't then proceed to apply to commit him in 2016. What it instead did was seek further orders to try and cure the breach that Mr. Watson had allegedly perpetrated of the earlier order. And we said that in those circumstances, there were two arguments in play. One, that it was simply impossible for a court to be looking at an order allegedly breached 4 years ago. It's just too much. The delay was too long. But secondly, by the claimant, by applying for further orders to cure the earlier alleged breach, had waived its right to apply to commit for the earlier breach. Now, in the event, the judge didn't have to consider those arguments because he found in my favor on other grounds. But I thought they were pretty powerful arguments myself. And therefore, delay or waiver or a combination thereof seems to me to be potentially a kind of argument that will find some degree of favor with a judge. The second point Is the breach alleged a technical one? Well, just to give an example, let's say a freezing order has been made against your client requiring an affidavit of means to be delivered by the 1st of February. And let's say, in fact, the affidavit is delivered on the 8th of February. And let's say there's no suggestion that there's been a dissipation of assets in the meantime. There has been a breach, but the breach has been cured and the claimant has not suffered any prejudice, let's say. Now, in those circumstances, an application by a claimant to commit your client for the technical breach would, I suspect, find very little favour with the court, and you might want to advise your client to issue an application to strike out and to bring that application on as soon as possible to get it squashed. And again, there's a very useful dictum from Mr. Justice Briggs in the Sector Guard case, which I've quoted, and which is elaborated further in the judgment. The third type of strikeout ground, again, I've mentioned it briefly in my little introduction, is the Henderson and Henderson ground. Now, there's a recent case called Taylor and Robinson, where the facts are set out very briefly. A contempt application issued in February 2020, alleging breaches of court orders dated February and June of the previous year. The application came on, I think, in June and was dismissed for whatever reasons. Doesn't matter. The application was dismissed on its merits. And what the defendant, in this case, was actually a defendant seeking to commit a claim. It doesn't matter. What the defendant then did was to then rootle around and say, aha, I found another order which was made against the claimants in July 2019. I'm going to found another application to commit them on in relation to breach of the July order. And what the claimants then did, they applied to strike out the defendant's committal application on the basis that there was no reason why the defendant, if he wished to found an application on breach of the July 19 order, could not have whacked it in, thrown it in to his February 2020 application. Why did he hold it back? This was a classic example of the application of Henderson and Henderson, now possibly described also as the Johnson and Gorwood jurisdiction. If you're going to make an application for a particular head of relief, then you've got to bring all your grounds and all your arguments at the same time. You can't hold things back and unleash them a bit further down the line. The result was that the claimants were successful in having the application struck out, irrespective of its underlying merits, on the basis that if the defendant wished to rely on that breach, he should have thrown it into his February 2020 application. So there's an example of the Henderson jurisdiction being utilised in a committal context and utilised successfully and effectively in that context. I wanted to just briefly move on to a little area. I say a little area, but it's had an awful lot of airtime of late in the cases. Now, one of the arguments that some defendants seeking to strike out committal applications deploy at the moment is to say, look, Judge, here's some allegedly without prejudice correspondence that was issued by the claimant or sent by the claimant at the same time as or just after they issued their committal application, trying to settle the case. And what that proves, says or argues the defendant, is that this application to commit is not brought for the genuine purpose of upholding the court's jurisdiction or seeking to ensure compliance with court orders, but is in fact being brought to try and crush me into settling on favourable terms from the point of view of the claimant. And this is just using and abusing the committal application to get a favourable settlement. And what they say is, these defendants, is that, and here's this WP correspondence, and although it says it's WP, in fact, it's not WP because we can bring ourselves within the unambiguous impropriety exception to without prejudice correspondence. And they try and rely on it to strike out the claim as being, to strike out the committal application as being vexatious. Now, that gives rise to this question. Is that correspondence in fact clothed with the WP privilege or not? Now, just a couple of points, there's an awful lot of cases on the subject which are referred to in the notes which we're going to send over, but a couple of high-level points. One is, undoubtedly it is the case that if a claimant uses a committal application to try and screw out of a defendant a higher settlement, which it would not otherwise have properly been entitled to, then it itself is probably committing a contempt of court and maybe indeed committing the crime of blackmail. So if you are acting for a claimant who is bringing a committal application, undoubtedly be careful in the correspondence you're sending, if you are sending any, seeking to settle the underlying litigation. On the other hand, and it's a very big on the other hand, judges understand that if you as a claimant have issued a committal application, and that may take 6, 8, 10 months to come on for trial, that doesn't mean that nobody can try and settle the underlying claim, that you simply got to put that on hold for fear of being told that you're a blackmailer. And in a decision of a year ago or so in Integral Petroleum, Mr. Justice Foxton said, well, you can see the words as quoted on the slide, judges again live in the real world. So therefore it is possible from a claimant's point of view to, having issued a committal application, to try to via WP correspondence, settle the underlying litigation. And indeed, no doubt, settling the underlying litigation will require settlement of the committal application as well. It's just a question of tone. And there's an awful lot of kind of subtleties attaching to that, which are analysed in the authorities, which we refer to in the notes. And I should say that a case I was instructed in last year, where we were about to have a 4-day committal trial, and that case was settled by way of a global settlement. It can be done, and it can be done effectively. But still something to be concerned about, whether you're acting for a claimant or a defendant, for different reasons. When should you issue your application to commit? There are 2 points here. Caley has mentioned that, broadly speaking, in the area we are practicing in, you are going to be applying to commit on behalf of your claimant client, either for a breach of an order or undertaking, or secondly, because the defendant has put in a pleading or a witness statement or an affidavit which contains a false statement. Now, if you are applying to commit for the first of those, on the first of those grounds, i.e. a civil contempt, then the law is pretty clear. You should apply immediately. When I say immediately, not necessarily the very next day, it's perfectly proper to try and encourage compliance with, for instance, the asset disclosure provisions of a freezing order. Perfectly proper to do that. And you're not going to put yourself out of court because you haven't issued your application the very next day. But what you mustn't do is let it lie for months on end. You must bring it, if you're going to bring it before the court at all, you must bring it before the court within the context of the breach itself. And in those circumstances, the court will then have a decision how to case manage your application on behalf of your claimant client. And in almost all cases, the court will bring that application on as soon as possible, and will do so for this simple pragmatic reason, that you, on behalf of your claimant client, have an immediate interest in securing compliance with the order you say has been breached. You don't want it to be the subject of a committal application brought on 2 years later. You want to know where the money is now, so to speak, and a court will absolutely sympathise with that and bring on your application well before trial. When I say trial, I mean trial of the underlying action. So that's scenario 1. Scenario 2 is perhaps a little more complicated, because scenario 2 involves a false statement of truth. And there, the broad body of authority, which we dealt with in the notes, and I won't go to the example given on the page there, is that applications to commit for false statements of truth should generally be made and come on after trial. Because typically the question of falsity will be an issue in the trial itself, and you shouldn't, as a claimant, have a kind of early hit on a defendant in advance of a trial. And Cole and Carpenter is the most recent of the authorities, which makes it absolutely clear that where the alleged breach relates to a supposed lie told in a witness statement or a statement of truth, then the time to commit is after trial. Procedural overview, I've been running over slightly, so I'm going to wrap this up relatively quickly. Part 81 came into effect on the 1st of October 2020. It simplified, undoubtedly simplified, in my view, a lot of very good material from the old rules and the old practice direction has been unnecessarily jumped. And I personally take the view that the old rules are useful and worth looking back on, and the notes to those rules in the White Book are useful to look back on, because I don't believe that the law has in substance changed, and everything said in those old rules, apart from questions of pure procedure, remain valid. You'll see that the nomenclature has changed, so we're now in the realm of contempt applications and claimants and defendants. Moving on, some notable points in the procedure. These are actually fairly uninteresting, it's fair to say, and it's a fairly uninteresting part nowadays, part 81. But there are some immediate bullet points about how you must go about bringing your application if you're acting on behalf of a claimant, and I'll say no more about that. Other than this very quick point about the grounds, there is a vast body of authority as to defendants asserting that the grounds of contempt as set out in the application notice are defective because they're not clear enough, or they're obscure, or what have you. And there's a lot of technical points taken by defendants over the years, and frankly, I've taken a few myself over the years. The test that the court will apply is set out by Mrs. Justice Cockrell in Sebastian Holdings, a very interesting judgment, I should say, and very much worth reading. And courts, although they say, yes, of course, a defendant needs to know what is being said against them because it's a penal jurisdiction being utilized, nonetheless, we live in the real world. We're not going to be impressed by hyper-technical points made by defendants to try and wheedle out of difficulties that they may be finding themselves in on the facts. So there's some procedural points, a few further procedural points set out there. One sentence on the third bullet point. There is this new sub-rule in Part 81, which says that the court itself has the power now to institute its own committal, its own contempt proceedings if it takes the view that a contempt may have occurred. And in a very recent decision before the Chancery judge, there was an attempt by a claimant to say, well, look here, judge, why don't you start issuing some contempt applications? Because look at the facts. And I think the short point that emerges from Isbellin is that in commercial litigation, the judges will take the view that the claimants and the defendants, if they take the view that the other side have committed a breach of an order or what have you, they're well able to look after themselves. And the courts are going to be very chary about stepping into the arena and instituting the application themselves. So I think in commercial situations, 81.6 is largely going to be a dead letter. It looks all very interesting, but it's in reality, judges are going to go nowhere near it. Some thoughts on the final hearing. Caley's mentioned quite rightly that the hearing will almost always be in public. And then some other points that emerge from the recent authorities. In the past, there was a sort of slight tendency on the judge to say that if the defendant hasn't shown up, well, I'm not very keen on going ahead in the absence of the defendant. That old chariness has very much gone now. And there's a whole host of cases decided in the last 10 years, which make clear that if it's clear that the defendant has voluntarily absented themselves from the litigation, then a judge will just carry on and hear the committal application and sentence accordingly if necessary. A few other points made there. One watchword point that I should emphasize, which is at bullet point 4, and where a claimant came unstuck. Even if the defendant is legally represented, make sure you or your advocate tells the court and invites the court to advise the defendant that he or she has a right to remain silent. If there's any suggestion or thought that the defendant wasn't aware of their right to remain silent and gave evidence ignorant of that right, or even possibly ignorant of that right, then you might find that your trial is rendered void or potentially set asideable on the grounds of unfairness. So just make sure that point has been brought home to the defendant at the trial to avoid some later argument on appeal. And the same goes for the entitlement to legal aid. And then finally, I come on to penalties. And I'm actually going to wrap up. I'm going to spend 1 minute on this because we've trespassed on your patience long enough, I think. There is a host of new law on penalties. There's some really important Court of Appeal and indeed first instance decisions decided in the last 2 years or 3 years or so, which are in the notes, which we're going to send through, and which show that the whole sentencing exercise has now been placed by the courts on a very formal and structured footing as to in order to get to the right answer sentence-wise. The critical point I wanted to make clear, and I think Caley has already mentioned it slightly, is that you're only going to, as a claimant, you're only going to get a custodial sentence if you can prove that the defendant acted contumaciously, that word that never is mentioned outside of a committal context, i.e. knowing that they were breaching the order. Although it's right that technically a contempt is committed, irrespective of whether or not the defendant knew that he or she was actually breaching the order, a finding of contempt on that basis is, from a claimant's point of view, going to be worthless, basically worthless, because no judge is going to commit a defendant to prison if that's all that's been proven. So you're going to have to, if you want to commit your defendant to prison, which probably you're likely to want to do, you're going to have to prove contumacy in that technical sense. I made a valiant attempt to suggest that a failure to actually plead contumacy in the grounds of the application notice invalidated the application notice. It's fair to say I lost on that particular point. So I think there are various other things we've set out in the notes. I'm looking through them now. We're going to send them through. But I see it's 20 to 2. You've been a very good audience. Thank you so much. I'm going to wrap up there. I don't know if there's any mechanism are there any questions, Caley, that you can see?
There is a question from Carmen Lapidus, who says, can you say more about dispensing with personal service, which is something we were discussing this week?
A very good question. Something I was going to say something about, but I was fearful of enraging my audience. I will say something about it because something I've thought quite a lot about of late. The old rule was clear. It said that you should dispense with, you should serve as a claimant the order, and that is a precursor to committal, but there is a power to dispense with personal service. And the old rules were absolutely explicit about that. The new rules do not say that in explicit terms, and I have no idea why not. But my own view is that the old law remains as valid then as it is, or is as valid now as it was then. And I mean, undertakings you don't need to worry about. An undertaking doesn't need to be personally served because, of course, it is issuing out of the mouth of the defendant themselves. But as regards orders obtained by claimants, clearly, it is vital to try and attempt to personally serve a defendant. On the other hand, a defendant may well do their level best to avoid personal service. Now, in those circumstances, then what I think you should do now is, best of all, is apply back to the judge before you issue your application to commit, to say, can you, judge, dispense with personal service? Because I've done my level best to serve this defendant and they're plainly evading service. Get that order in advance of making your committal application. And indeed, the new rule seems to suggest that that's what you should do if you're going to seek a dispensation. I don't think it's absolutely critical that you do that. And I think that it must be possible for you to issue a committal application and seek a dispensation within the application itself. But the rule is sadly not absolutely explicit about that. It's fair to say that even if you can't prove as a claimant a evasiveness on the part of the defendant, an actual obvious and conscious attempt on the part of the defendant to avoid personal service if you can show that that the order came to the defendant's attention. And typically you can do so by you've served the order by email, let's say, and the defendant's replied on the same email. In those situations, I suspect that a court will be persuadable that you can proceed to commit, even if you haven't proved personal service. But the watchword must always be try to commit to personally serve, and only give up if the defendant is obviously seeking to evade personal service. It's fair to say the law on penal notices is rather more complicated, and I argued it at great length last year, and in the event it wasn't ruled upon. But there is a vast body of authority on penal notices, which again I think is equally applicable now as it was under the old rules. You're probably in more trouble as a claimant if you haven't put a penal notice on your order and you're trying to dispense with it. But I think putting it very crudely, the broad law is as follows: that you will only persuade a court to dispense with the existence of a penal notice if you as a claimant can show and can demonstrate very clearly that the defendant was, by hook or by crook, even if there wasn't an actual penal notice in the prescribed form on the face of the order, if you could show the defendant was aware that breach of the order carried with it potential penal consequences. And that may be done by way of a letter serving the order. For instance, solicitor's letter serving the order, saying in the letter, by the way, Mr. X or Ms. Y, if you breach this order, then the following potential consequences can apply. There are cases which say that that is sufficient for the purposes of a judge being willing to dispense with a penal notice. I think I've given a rather far too long an answer. Are there any more questions, Caley?
No, that's it, unless there's any...
Other than the only other question is stop now. So should we wrap up then?
Yeah, absolutely.
Many thanks all for staying the course.